I'm in chambers, so we're going to go live on YouTube to meet the open courtroom requirement. I went out in court and some other folk are using the courtroom right now, so we will make this work, and as long as there's no objection from anybody.
No objection.
That's fine, Your Honor. Thank you.
Okay. So we are streaming live on YouTube to meet the open courtroom requirement. I know there was and I was looking at a motion filed to amend the pretrial order and then an objection. Let me hear about the motion to amend.
Yes, Your Honor. Thank you. My name is Tony Lehman. I'm here on behalf of the plaintiffs, Joy Nakrin, Andy Nakrin, and Teresita King. We were hired in April of 2024 to represent the plaintiffs in the lead up to trial. At that point, the motion for summary judgment had been heard by this court and decision came out. Prior to that time, previous counsel and Mr. Schreck had agreed to reserve taking expert discovery until after the motion for summary judgment hearing. So that has, at this point, has yet to be done. No one has taken any expert depositions at this time. So during the time that we were getting up to speed and getting involved, I learned I had to have surgery in August, which led to my medical leave in August and into September. But during that time, we spoke with the prior expert, Mr. Wilkie. We got an engagement letter from him and we sent it back to him in early June of this year. That's the last time we've heard from him. We've sent him multiple emails. We've made multiple phone calls in an effort to try to talk to him about the case, to try to get to a point where we could schedule depositions. And we have left multiple messages. We have sent, as I said, multiple emails to a number of different email addresses, and none of them have been responded to. I have no explanation as to where he is or why. I mean, we know he's still around. As Mr. Schreck pointed out, he's been appointed to the Well Water Committee by the state. He's an adjunct professor in the engineering department, University of Georgia. All those places are great, but unless I stalk him at those places, I can't get him to respond to my emails or calls. So as a result, when I came back from leave on September 24th, that was the first day my doctor let me go back to work. One of the first things I addressed was my inability to hear from and talk to Mr. Wilkie by reaching out to a number of different expert firms to try to find someone to replace him as an expert. We interviewed several people. That was in early October. We retained Mr. Krentke, who is our current expert as disclosed. We notified him we were retaining him on Monday, the 21st of October. We received this court's notice of trial on the 23rd of October. That night, I received an email from Mr. Schreck at about 10 minutes till 9, asking me about, potential case settlement issues that you always would talk about, but also the issue of expert discovery. In that email, he stated, "I know we discussed allowing for discovery depositions of the experts, and I'm still okay with that if we can find the time. If there are any evidence depositions to be taken, please let me know." So I responded the next morning, said, on another note, our previously disclosed expert has gone walkabout on us. I have no idea where he is. We have not spoken to him since we sent his engagement letter back to him. As a result, we need to substitute a new expert in. I will get you that new expert's information in the next day or so. I was waiting on getting his engagement letter, so the engagement was official. I hope you will consent to allowing us to make this substitution in the CPTO. We will be seeking to do so if in the next couple of days, with or without consent. Mr. Schreck responded, said that we feel prejudiced by that fact, that it's too late in the game. I'm not trying to be difficult, but this case had a scheduling order. Discovery's been over. He's like, I have to have time to consider your expert's opinions, take his or her deposition, identify rebuttal experts if needed. And he said, it sounds like you don't have an expert lined up yet with me on another trial calendar until November 8th. In this case, set to be called for trial in less than 3 weeks. I simply don't have time to do all that and cannot allow my clients to be prejudiced by this very last minute change. And my response was, we have our expert lined up. Your expert doesn't have an expert report that's been provided. To my knowledge, we have an affidavit, but that's it. And neither party has taken an expert deposition, so I asked where the prejudice was. And the prejudice, he said, was in disclosing experts previously a year prior and providing opinions in supplemental discovery. He didn't prepare a report, but an affidavit outlining his opinions, which was also provided to formal counsel. Your clients have had a year to take Bob Kenny, Bob Kenny's deposition. I would be given a few weeks at most whenever you disclose the name of your expert and his or her opinions, during which I'm scheduled to try a case. So that's where we are. That's the discussion here. In essence, we are seeking to be able to have an expert at trial with this substitution. And in the interest of, we understand you have the discretion to determine whether to amend the pretrial order. Indeed, under OCGA 911-16B, when you're disclosing an expert witness after entry of pretrial order, it's within your discretion to permit or disallow that presentation of testimony. But if that expert witness is permitted to testify, they should be permitted reasonable time to take that deposition. In this case, we would ask that the pretrial order be amended. We have 2 weeks. I understand Mr. Schreck obviously has a trial calendar to deal with, and I'm not sure how long that trial would be. We can work around that and make it work. We will make Mr. Prentke available for a Zoom deposition, very quickly. He is actually here in Atlanta today to make sure he is doing all of his work, so he'll have his opinions finalized within the next day to 3 days. Obviously it takes a little time for him to come to a final opinion, but he'll have his fact-finding done and his opinions finalized within that time, such that we can make him available at Mr. Schreck's disposal, assuming, of course, availability from Mr. Prentke. But we're willing to do all that to make this work. And in the interest of fairness and justice, we would like that pretrial order to be amended to make that change and revise it from being Mr. Wilkie to being Mr. Prentke. And I'm open to any questions you may have, Your Honor.
No, I think I understand the setup. Attorney Schreck, any objection?
Your Honor, yeah. I think the lawsuit was filed in September of 2022. So we're 2 years past the lawsuit being filed. Discovery ended pursuant to the case management order over a year ago, October 27th of 2023. So, the plaintiffs have filed this motion to amend the pretrial order on October 29th of 2024. We did get supplemental discovery responses. In my objection, I indicated we did not have them. We got supplemental discovery responses about 35 minutes prior to the start of this hearing. And, in our interrogatories where we inquired about experts, we ask for information, that's standard, that you ask for the subject matter, the substance, the facts of the opinions, any basis for those opinions, things like that. The response we got, which I appreciate, simply says that they've identified Mr. Walker Prentke and that he will testify concerning hydrology, the estimated water volume flowing onto plaintiff's property, stormwater runoff, and the impact of defendants' actions in diverting stormwater runoff onto the property. As Mr. Lehman just suggested, it sounds to me like the expert hasn't even been out to the property yet. And he's telling us we're going to get his opinions maybe in 1 day, maybe in 3 days. 3 days takes us into November, and even 1 day takes us into November. But if I don't get those opinions until next week, Judge, I am on on call, 4-hour call for a case in the state court of Fulton County. That it will be about a 3-day trial. I don't know that we'll be reached next week, but if we are, that's 3 days of the 5 days next week prior to this trial calendar that I really won't have the ability to depose this expert. I'd also say, as of right now, we still don't know the expert's opinions, assuming he has any. We don't know what facts he based his opinions on. If we don't have that information, I don't know how I'll be able to know what methods he used, what principles he's basing any of his opinions on until much, much closer to trial. So if we wanted to file a Rule 702 motion, we've got almost no time to do that. And so, I'm not trying to give Mr. Lehman a hard time. I do understand and appreciate the situation he's in as well. But I would argue that, it's within the court's discretion to disallow this new expert at this very late hour. And if the court's not willing to do so, I guess at minimum, I would ask that we be permitted pursuant to the statute, a reasonable amount of time to discover the expert's opinions and qualifications, take his deposition, evaluate those opinions, give those opinions to our own expert who has been on board for well over a year, or hire a rebuttal expert if there's something new that he can't address. And I just don't think all of that can be done in a week, especially with the real possibility that I'm going to be in court for some of those days. So, again, I'm not trying to give Mr. Lehman a hard time. I understand that it is within the court's discretion. And, if this expert is allowed, I would simply ask that we be given sufficient time to conduct the necessary discovery. And I don't think I have that at the moment, unfortunately.
Okay, Mr. Lehman, anything else?
I mean, as Mr. Schreck recognizes, I didn't want to change experts. I'm in a position where I'm literally, in many respects, almost begging the court for its both forgiveness and its action in allowing me to do so. This isn't something I wanted to do. I didn't come into this thinking I've talked to Mr. Wilkie and he's going to be a terrible witness and I need a new one. I haven't talked to him. I have no idea what kind of witness he is. And so, I mean, this is literally to be able to have an expert witness in this case for my side. I mean, I guess if the court in its discretion decides not to allow this amendment, I'll come up with some way that's at least legal to track down Mr. Wilkie and sit outside his house waiting for him or something to make sure I get to talk to him or something. But that's pretty much where I am at this point, Your Honor. So I would ask that the court exercise its discretion, allow us to revise the pretrial order to substitute Mr. Prentke as an expert. If there's conditions such as additional amendments to our interrogatory responses within a short period of time, we're willing to do that and happy to do that. We'll meet those conditions and make that work.
Okay, here's my thought process. I could do exercise my discretion, allow you to remove Mr. Wilkie and substitute your new expert, but then I need to give the defense time to do their due diligence and their discovery on the expert and their opinion. The next time we could have you back in court for a trial is not until next year, January 2025. So if you all are willing to wait until probably January 20th of next year, then you can have your witness, the defense can have time to do their discovery and due diligence on the witness.
I'm agreeable to that. I know that my clients won't be super happy with me agreeing, but at the same time, I think it's the right answer here to allow Mr. Schreck enough time and allow my expert enough time as well. So that way we're not just rushing around trying to get things done without having, proper consideration for everything necessary here.
Okay.
I agree, Judge. I'm sorry.
Yeah, go ahead. I'm sorry.
I was going to say, I'm in the same boat. I'm sure my clients won't be thrilled. They're ready to get this over with, but I think it also agree it's the right decision, and I appreciate it very much.
And so then that leaves the issue of discoveries closed, reopening discovery for the limited purpose of what? What do we reopen discovery for the limited purpose of taking depositions, or what are we talking about?
I think taking expert depositions, Matt, would that be the fair statement?
That's all that I think we need to do. Yes, correct, Your Honor.
The one expert, we're not going to open it for everything else. Just to deal with the one new expert. How long would you all want November to get that done? Like whatever was it December 1st? Is a month enough? I guess my question is a month enough time for you all to turn over the information from the expert and to give the defense time to do their deposition?
I think that should be okay.
Yeah, Judge, and I promise Mr. Lehman and I will work together on this. So if you're talking a January 20th trial calendar, even if we have to go into December a little bit, I'll make my expert available for a discovery deposition as we previously promised.
Well, that's what I don't want to do is I don't want to get here in January and it's like, oh, we just got this information. We need more time to digest it and understand it. So I want to, if you all are telling me, November, December, if you get it, December 31st, that's gives you what, 3 weeks or 2.5 weeks before trial.
We,
That,
I will agree to that, Your Honor. I'll agree to those conditions, however long that Mr. Schreck needs to be able to schedule himself for my expert's deposition, and I appreciate him also making his expert available and on that vice versa issue of me being able to take his deposition as well.
so we're
Yeah,
thinking,
yeah, go ahead.
no, you tell me what you're thinking.
No, that's fine, Judge. I mean, my goal would be to do it much sooner than December 31st, and I think Mr. Lehman and I can work together to make that happen. And I promise, if I can get the opinions that this expert has, we had no objection to the prior expert because I knew generally what he was going to say. I can take a quick discovery deposition in an evening, but a whole new expert was just a whole different issue to deal with. But if as Mr. Lehman's saying, he's in town and we're going to have his opinions by next week, I feel confident we can be ready for trial January 20th.
Okay, so here's what I'm going to ask you all to do. Get me an order. Mr. Lehman, get me an order. Run it through Mr. Schreck. That I'm allowing, exercise my discretion, allowing you to substitute the new expert, withdrawing the old expert. I don't want both of them. And that we'll reopen discovery until December 20th. We'll reopen discovery until December 20th, Friday, December 20th, to take expert depositions.
I will do that today, Your Honor. Thank you.
All right, I think that covers the issues. You all let us know if there's anything else.
Thank you, Judge. We really
I
appreciate
appreciate
it.
it, Your Honor.
All right, have a good weekend. Thank you.
Thanks, you too.
Thank you.